Ready? Start. He also stated that brother of the deceased deposed that his sister had told him that her in-laws taunted her about being from a poor family and for having brought less dowry. PWS 3, 4 and 5 allege that the accused burnt Bhagwati to death. PW6 Dr. Naval Kishore Pandey, the doctor who conducted the post mortem of the deceased, deposed before the trial court that she had died due to 90% of burn injuries. PW7 Deepak Chandra, another brother of the deceased, deposed before the court that he had gone to his sister's matrimonial house in May 1993 when the accused persons demanded rupees 30,000 and said that dowry was not fulfilled by the parents of the deceased and they had simply given a sewing machine. He also stated that the accused person had misbehaved with his sister Bhagwati in his presence. This case has been referred to this bench for a decision of the question whether in a letters patent appeal the time requisite for obtaining copies of the judgment and decree should be excluded in computing the period of limitation fixed by the rules of this court for preferring a letters patent appeal. A full bench of 4 judges of the Allahabad High Court in Fazal Muhammad v. Full Court has to be considered and if found to lay down incorrect law has to be overruled. We think in these circumstances it would be advisable that a bench of 5 judges be constituted in order to decide the case. We therefore direct that the papers of this case be laid before the Honorable the Chief Justice for constituting a larger bench. The question which has been referred to this bench in whether the time required for obtaining copies of the judgment and decree appealed from should be excluded in computing the period of limitation for preferring an appeal fixed by the rules of this court under the letter patent. The relevant facts are that judgment in 2 connected second appeals was delivered by Brij Mohan Lal J on 3/10/1915, the learned judge granting leave to the present appellants to file a further appeal under the letters patent. The letters patent ceased to have effect from the date upon which the UP High Court Amalgamation Order 1948 came into force, but by virtue of Clause 9 of that order and Article 225 of the Constitution rules with respect to the practice and procedure of the former High Court are applicable to the present court, and although not strictly accurate, it is convenient to refer to the rules which we have to consider as made under the letters patent. On 11/10/1950, an application was made for a certified copy of the judgment and decree. The copy of the judgment was ready on 22/0/1951 and delivery was taken on the following day. The copy of the decree was not, however, ready until the 5th March and delivery was taken on the 7th March. In the meantime, on 21st 2nd 1951, the appeal was presented but was not accompanied by a copy of the judgment. Paras 2 and 3 of Rule 7 of Chap 3rd of the Rules of Court as then in force. Subsection 2 of Section 16 of the Arbitration and Conciliation Act provides that a plea that the arbitral tribunal does not have WPC numbers 6328/2013 and 4886/2013, page 1 of 15 jurisdiction shall be raised not later than the submission of the statement of defense. Subsection 3 of the aforesaid section provides that a plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceedings. Subsection 5 of the aforesaid section, which is relevant for the purpose of these petitions, reads as under. The arbitral tribunal shall decide on a plea referred to in subsection 2 or subsection 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings and make an arbitral award. Section 37 of the Act, to the extent it is relevant, provides for an appeal from an order of the arbitral tribunal accepting the plea referred to in subsection 2 of subsection 3 of section 16. No appeal, however, is provided in case such a plea is rejected. Section 5 of the Act provides that, notwithstanding anything contained in another law for the time being in force in matter governed by Part 1st of the Act, no judicial authority shall interfere except where so provided in the said part. Source is 3P Legal rhc and exercise number is 47. Words are 758 and the speed was 100.